Good morning. A reminder, unless the case has been, we put an order down excusing it, it'll be broadcast live on the AOC web channel, and then the oral argument will, and then will be placed on the YouTube channel, AOC YouTube channel. Just something to keep in the back of your head. If you would call the first case, please.
Derry M. Thompson et al. v. Timothy A. Graham et al.
We'll hear from the appellant when you're ready.
Good morning.
Good morning.
May it please the court, my name is Chris Kane, and I, along with John Brock and Ed Shipe, represent the appellants Timothy Graham and Graham Corporation in this appeal. I would like to reserve 3 minutes for rebuttal, and I would like to request the grace of the court and allow Mr. Brock to use those 3 minutes to speak the rebuttal and close the argument, if that's okay.
That'll be fine.
Thank you. There are two issues I'd like to discuss. One is somewhat preliminary. The first is whether this court has to, should consider this appeal and whether it has jurisdiction to. And the second issue is as to the merits of whether the trial court erred in enforcing a purported settlement and taxing the costs later in a subsequent order to the appellants. The standard of review on all these issues is contained in our brief. I'm not going to go over them unless the court is interested in that. But on that preliminary issue, on March 18th of 2024, the trial court entered an order granting a motion to enforce settlement filed by Mr. Thompson. On March 22nd, 2004, the trial court entered an order taxing all costs to the appellant. As a precaution, the appellants filed a notice of appeal with respect to both orders in a single notice of appeal. It's our position that the March 18th notice of order was not a final judgment, and that the March 22nd may be a final order. On April 12th, we mailed our notice of appeal as to both orders. It was received and stamped by the clerk and master of the trial court on April 17th, and it was stamped filed by the appellate court clerk on April 18th. The record was transmitted in June. This court put down an order as a show cause order, telling us to show cause why this court has jurisdiction, that the notice of appeal was untimely. We responded thereafter. This court put down an order saying it should be, that issue should be addressed in the briefs on appeal. I want to start by saying that March 18th order was not a final judgment. It was simply an order granting a motion to enforce settlement. The motion that was filed did not even seek final judgment. It simply sought an order enforcing the settlement. The motion was not a dispositive motion. There's no unequivocal language indicating finality. Thus it was interlocutory and subject to revision at any time before final judgment.
Mr. Kane, what was left for the trial court to do other than the taxing of costs?
Dismiss the case, and if the court is probably familiar with the purported settlement agreement, this purported settlement agreement required that the parties ultimately submit an order of compromise and dismissal, dismissing with prejudice the complaint and the counter complaint. That had to be done. That had to be done. And we've cited this in our brief that for an order to be final, and this is from the estate of Henderson case, it must leave nothing else for the trial court to do. And as I've just described, there was more for the trial court to do, and in fact the trial court did more. On the 22nd of March, it entered another order taxing all of the costs of the case to Mr. Graham. That order is contrary to the terms of the settlement that was supposedly going to be enforced. The settlement provided that costs would be taxed equally between the parties. The court, for whatever reason, put down an order taxing all the costs to Graham. We cite several cases in our brief. They're out-of-state decisions, because I don't think this issue's been directly addressed by the Tennessee courts, but these out-of-state decisions that we cite make it clear that granting a motion to enforce a settlement is not a final judgment. The case cited by the...
Well, tell me again, what was different in the second order from the first order, other than taxing cost?
Well, if you take the first order on its face and enforce the settlement expressly provided for...
I understand what you said, but I'm just looking at the two orders. What was different in the second order from the first order other than taxing cost?
I don't believe there was anything different, but that changes the order of March 18th, because under the order of March 18th, costs would be taxed under the settlement equally. The order on the 22nd changed that.
Was anything presented to the court between the two orders, any form of motion or request?
No, Your Honor. The court acted sua sponte and put down that order. There was nothing filed, as far as I'm aware of, nothing prompted the filing of that order.
If there's nothing different between the two other than the taxing of the costs, and March 18th is not a final order, is this appeal not premature because March 20th is not final either? Or whatever the second one is.
Well, arguably, that may be the case. I believe that, and that question's unclear to me, frankly. And that's why we filed the notice of appeal as we did, because it was unclear whether at that point there was a final order. But that's the best I can answer your question.
So your overall point is there should be an order of compromise and dismissal before it's final?
Yeah, or something that, yes, under these circumstances, or that order of March 18th should have said, case dismissed. Either one of those would have done that. But that's not what happened. We don't have a final order. And again, the cases we cite from out of state make it clear that simply ordering enforcement of a settlement on motion is not a final judgment. We've talked, alternatively, if this court disagrees and thinks that it does not have jurisdiction, we would, and this is in our papers, and I want to get to the merits of this case, but we would ask it to be remanded under for Rule 60.02 consideration by the trial court to see if there are reasons to vacate that order and re-enter an order so that we can be timely if the court is inclined to believe that. We're going to turn to the merits here. Court put down an order, and in that order, bear with me, I'm sorry. She found that there was evidence of a settlement and meeting of the minds. There was no basis to render the proposed agreement unenforceable. There was sufficient evidence of a writing to satisfy the statute of frauds. Respectfully, the trial court was wrong on all fronts. There was no meeting of the minds here. The linchpin of the argument that there was a meeting of the minds is my September 7th, 2021 email, wherein I send an email to Mr. Hale attaching a terms of a settlement. Terms of the settlement, that document included a signature line for 4 people, Mr. Graham, Mr. Thompson, Mr. Hale, and myself. I tell him that I intend to send this document to Mr. Graham and that I invite him to comment on it, whether it is okay. I did not ask for him to sign it, did not ask for his client to sign it. I did not make reference to any offer, that it being an offer. I wanted to get completeness and make sure it was correct before I sent it off to Mr. Graham for purposes of him blessing it and or signing it. There was no meeting of the minds. And it's important to recognize that the signature element of this document that I attached, the 4 signatures, was something that Mr. Hale added to that document. Clearly, for there to be an agreement and a meeting of the minds, there had to be 4 signatures on there. Mr. Hale sent it back with his signature and Mr. Hale's and Mr. Thompson's signature. At that point, it was an offer. It was an offer to be shared with Mr. Graham for him to either sign or not sign. We flipped it around here. It's just like a real estate contract when you're talking about buying a house. What happens is the offers and counteroffers are signed, sent to the other side. That's when it's an offer. When they sign it and send it off, and they ask for the signature of the other party. If the other party doesn't sign it, they make a counter. They sign that counter, send it back to the other party. Until both sides have signed it, it is not a deal. And I want to be clear about this. And this is from the restatement of contracts. A willingness to enter into a bargain, and there was a willingness to enter into a bargain, is not an offer if the person to whom it is sent knows or has reason to know that the person making it does not intend to conclude a bargain until he has made further manifestation of assent. 4 signature lines requiring Mr. Graham and my signature. That is a clear indication of there was a need for assent, and signatures were required for that assent. Again, these are signatures that Mr. Hale put on that document. So respectfully, if you're an outsider looking at all of this and you've got this document and it doesn't have Mr. Graham's signature on it or my signature on it, and it calls for those signatures, you don't have a meeting of the minds. You simply don't. Objectively, you do not. I'm down to 39 seconds here. I'm going to briefly go through the other bases, and we've briefed all of this. Trial court put the burden on us to show that I did not have authority to act on behalf of Mr. Graham. The burden was on those folks. They didn't meet that burden. We had the continued negotiations after September 7th. The restriction easement, right of first refusal document was a cloud on this title. It didn't provide for clear and marketable title. And I'd like to refer you to this, the Tennessee Uniform Electronic Transmission Act. The trial court indicated that my email was sufficient to meet the requirements of the statute of frauds. That email, all that's on that email is a form block at the bottom with my name, contact information. And under that act...
Counsel, you've used your time.
Okay,
You
thank
have
you.
your time for rebuttal.
All right, thank you.
We'll hear from the appellee.
May it please the court, Tom Hale of the Knoxville Bar here on behalf of Derry Thompson. I would like to quickly make a couple of points about the timeliness of the appeal. I think it's pretty clear under the cases cited in our brief that the question becomes, is there anything else for the trial court to do in determining whether or not it's a final judgment? The point that gets lost in this case is that the settlement agreement itself, the document that was being enforced by the court's order, provided for the complete disposal of the case after litigation since 2013. We've been litigating this thing for a long time. And the document itself has language in it that the parties are releasing one another from all known, unknown claims that could have been asserted and that were asserted in the lawsuit. That is contained in the 4 pages of the settlement agreement. So our fundamental position on the timeliness is that it clearly was timely, and an order on costs is clearly not the kind of thing that prevents a final order from becoming final. That's clear in the case law. So respectfully, we say that there's really no reason to not realize that this case or this order was a final order. And I will say one other thing about the facts. We got this order on March the 18th. Mr. Graham filed a motion wanting to go down and find out what the status of the case was after we argued the motion 2 years before, the motion to enforce. And we got there. First thing Judge Stevens did is hand all the lawyers and the parties her order of March 18. So we had it on March the 18th. If the court wants to excuse people from filing late appeals because of the mail, the law could always be they measure the time from when the postmark is on the mail when they're sending in their notice of appeal. That's not what the law is. It has to be in the Court of Appeals within the time frame. It was not. I don't like arguing this particularly, but that is the fact. And if we're going to make excuses for the mail delay, then we're going to have this in every case, potentially, where there's an issue with the post office. Let me, if I could, unless you have questions for me on that score, let me move to the other, which is very dear to my heart. The question of whether there's a meeting of the minds is a question of fact. It's to be determined by the trial court whether they find a meeting of the minds as to the essential terms of the settlement. The findings of the trial court are presumed to be correct unless the preponderance of the evidence is otherwise. Here, the preponderance of the evidence based on the court's findings are not inconsistent. I mean, the court's findings are not inconsistent with the preponderance of the evidence. In making findings and conclusions about a meeting of the minds and mutual assent, the cases are pretty clear. You determine that based on whether a reasonable onlooker, based on the parties' outward manifestations, would conclude that the parties agreed to be bound by the agreement. Further, what are those outward manifestations? Scanlon versus McDill says, or it teaches, it not only the words are used in determining that, but you also look at the situation, you look at the acts, you look at the conduct of the parties, and all of the attendant circumstances. My position, or our position, is that the problem with the appellant's arguments are all, they want to look at snippets, look at this little language of this email, and ignore everything else that was going on. To me, the first argument that this was not an offer, this September 7 email with the attached 4-page document was not an offer. To my mind, that the most compelling argument or evidence against that is the process by which the agreement came into being. If you look at the appellant's brief, I think it's on page 26. This is what the appellant says about the process. In May 2021, after nearly 8 years of contentious litigation and 3 years of trying to unwind Thompson's unlawful distribution, the parties began discussing a settlement. Thompson made offers on May 13, June 29, August 4, August 10, August 20, August 30, and September 3rd. Graham countered on June 16, July 29, August 9, August 17, August 24, September 2, and September 14. Well, that's 14 different offers and counteroffers total, 7 each. The only one that's not mentioned in that list is the one that would have come after Mr. Thompson's last one, which was on September the 3rd. So on September the 7th, that's the one that was the offer. That's the one that on the email said that it was a settlement agreement with Exhibit A, final, in all caps. PDF. That document was converted by Mr. Graham's side and was sent back to me. I got it, sent it, communicated about it, that we would get it signed. They said they'd get it signed. So that string of emails and offers and counteroffers indicated that the parties were making changes and getting to a final result, which they did. I think even more compelling than that is the court's express finding that Mr. Graham, by his own testimony, was the one formulating the offers and the counteroffers for his attorney to convey. Finding paragraph number 11 in Judge Stevens' order says, during the negotiations, Mr. Graham was formulating the offers, which were then provided to his counsel for communication to Mr. Thompson through Mr. Thompson's counsel. Attempting to distance himself from the agreement now, the argument in the brief is that, well, Mr. Graham didn't really have anything to do with these offers. He hadn't endorsed it. I mean, you look at page 49 of Mr. Graham's brief. I'll quote, and it's speaking of the attachment to the September 7 email from his counsel to me. The implication, dash, a false one, dash, is that Graham had endorsed the proposed agreement before Kane emailed it to Hale. Well, what else are we supposed to think? Whose offers were these if they weren't Mr. Graham's? Mr. Kane's? I don't think anybody believes that Mr. Kane is going to be making offers in a complicated case like this without going to his client and getting authority to send the document. So, in his...
Mr. Hale, I'm sorry to interrupt, but just to make sure I understand, it's your position that the September 7th email from Mr. Kane was the offer that was then accepted by you when your client signed it. It's as opposed to the parties having been negotiating for months and months and months, having already come to a meeting of the minds and an agreement that the offer and acceptance had already been made prior to the final document being sent.
I think the process of getting to that final document was a process. And when that final document was submitted to me on behalf of, for my client to consider, and my client accepted it by signing it and sending it back. That was an offer.
Let's assume, hypothetically, that he had sent that email and your client didn't sign it. You said, no, I don't agree to that.
It would have been an offer that was rejected.
Okay,
Like all
so
of those.
it's not your position that we had already done all this. This was just a formality. It truly is the offer and the acceptance. Okay.
Yeah, all those previous offers were Word documents that went back and forth with redlining, and eventually it got down to a point where, and that's the most compelling evidence of all, is on September the 7th, Mr. Kane and I called Sasha Combs, Judge Stevens' assistant, and informed her that the case had settled and the case could be taken off the court's trial docket, which was set for in October, shortly thereafter. And why would we do that? Why would we do that if it hadn't been resolved?
Other than the signatures, were there any other changes to the, any other changes to the document that accompanied the email, other than the signatures placed on it?
No, not that I'm aware of. I didn't make any. I mean, it was a PDF that got sent to me by Mr. Kane, attached to the September 7 email. I had my clients come into the office, signed it, I signed it, we emailed it back to them. There was no changes to that document. And you all, the document, if you read, you ought to read the document. The document is a pretty interesting document. It is a very detailed agreement that was written so that this kind of thing would not happen. It was written so that all details would be taken care of. And if you look at it and read it, you can see we were trying to make sure that we didn't have anything like this happen. And so, one other point I'd like to make before we get too far afield here, and I'm about to run out of time. Much has been made about the issue of the title commitment and the request for the title search. Well, the document itself was given to me at 5 o'clock. No, I'm sorry, earlier in the day. I sent it back signed at 5 o'clock. Mr. Graham didn't request the title commitment from Joe Huey based on Joe Huey's testimony until 7:15 that night. So a deal was already offered and accepted before this title commitment that has created all of this hoopla in this case and required a hearing and experts that completely, in my opinion, completely irrelevant to what this case is about or what we were about at that time. But the point is, it was all done before the title commitment was ever asked for. I guess the other there is a bunch of argument about that we were continuing to negotiate after the September 7 email was signed and sent back. If you honestly look at the communications, and I believe it's Exhibit 16 to the trial transcript, all that was happening was Mr. Kane and Mr. Graham were trying to reach Broadreach, and I sent them an email. And I said, well, you can deal with them all you want, but that shouldn't affect our settlement. Well, they didn't write back and say, oh, we don't have a settlement. What are you talking about? They asked for patience, so we gave them patience. And this is what we get for it. It's used against us because we were trying to accommodate them while they worked with Broadreach on an issue that had nothing to do with this contract. The conveyance of the 12.53 acres that we're talking about that got the title commitment on, that was not one of the properties that was to be conveyed under the settlement agreement. Those were two other pieces of property that had nothing to do with this title commitment. This property was transferred to Mr. Graham 2 years before, I think it's 2 years, July of 2019, as part of a distribution from the partnership in liquidation of the partnership. He'd had that property and it had been sold. All of the issues had come up 2 years before. So now we're trying to make it as if somehow or another that piece of property and its title had something to do with this settlement. The only thing it had to do with this settlement is that's the very kind of claim that was supposed to be released and dismissed as part of the settlement. That's what we were trying to do. All this stuff in the past, all this history, the parties were agreeing to mutually release each other, keep what they had, and move on. The title commitment property had nothing to do with the outcome of the settlement. It was just something that Mr. Graham decided to do at the last minute, and here we are.
Counsel, you used your time.
I have.
You have.
Sorry.
We'll hear from the appellate rebuttal.
May it please the court, my name is John Brock. I am founding and managing partner of Brock Scheib Klink for 29 years. I've practiced contract law, and I serve as Mr. Graham's contracts attorney in many of his transactions. The lower court's decision creates a new standard for attorneys. Never have I been taught or told or presumed that I had the authority to bind my client without my client's express written consent. Clearly here, the contract suggests that such consent had not been given because it required Mr. Graham's signature. If, in fact, that consent had been given, then it just would have required Mr. Kane's signature. A decision by the lower court, if allowed to stand, would cast a chilling effect on all attorney-client communication, attorney-to-attorney communication, which would be a new standard that all attorneys under the jurisdiction of this court would be bound by, that would not be binding on any other attorney in other jurisdictions that I know of.
Mr. Brock, what do you say the email of September, I don't have the date, 8, 9, whatever, 7, that was sent by you, or maybe it was Mr. Kane, to Mr. Hale, what was that, if not an offer?
Well, you heard Mr. Hale, who I greatly respect, give a lot of evidence that the parties were striving to finalize a deal. In my world, we call that parole evidence. It's evidence outside the bounds of the contract to try and say that there was this meeting of the minds. My contention is that the contract itself is plain, and you don't need to resort to that type of parole evidence. There are conditions to closing in just about every transaction. Here we have the condition that the parties sign. It was clear. Mr. Hale himself included the signatures in the document. That condition was never satisfied. There's another aspect of this that Mr. Hale pointed out. This was intended to be a waiver and release of any and all claims. Part of the disputes that the parties had involved that 12.53 acres that had been distributed by Mr. Thompson that was in dispute. That was part of their disputes. Whether or not it was part of this settlement agreement, the global waiver and release had to do with the dispute over that distribution. A condition to the resolution of that dispute required the recording of a deed. The deed warrants title, including all matters of public record.
Let me ask you a quick question before your time is up, but I'm going to ask you a
Yes, sir.
question. What, if it was not an offer, what was it?
It was a continuation of the parties' negotiation to a final settlement, which was conditioned on the execution by the parties of that agreement.
Okay, it was a continuation of the negotiation.
Your Honor, I submit if Mr. Kane had the authority by virtue of that email to bind his client, then we're talking about a whole new subset of rules on attorneys that, in this case, involves the dispute among partners. But what if it's a paternity case like the one going on across the hall right now? What if it is a criminal matter? You know, at what point do attorneys, in the entirety of their communication with opposing counsel, have the authority to bind their clients in these
But
matters.
attorneys all the time in settlement negotiations communicate offers on behalf of their clients.
Your Honor, if I
Correct.
handed you an unsigned deed as counsel for my client, if I handed you an unsigned deed for the transfer of property, you would of course insist that it be signed. When I give legal opinions on transactions.
So, and your position is if the lawyer communicates an offer, it's really not an offer unless it's been signed by his or her client.
My contention, Your Honor, is if it's an offer in this case, it's subject to the completion of the conditions required to complete the transaction. One of those conditions, and a major part of those conditions, was that the parties sign the document, as evidenced by Mr. Hale
Okay, so an
and his
offer
client
from a
sign.
lawyer is really not an offer unless it's been signed. It's a sort of offer.
Well, it's an offer subject to the accomplishment of the conditions,
It's
right?
that it be signed.
That it be signed.
Okay, thank you. Thanks to all counsel. We appreciate your arguments today and your briefs on this, and we'll get our opinion out as quickly as we can. Thank you.